Welcome back to Canadian Justice, where we're discussing a court challenge to Canada's first-past-the-post voting system and why the organization I work for, the Canadian Constitution Foundation, believes this system is perfectly constitutional. Now, Chris, you have been working on this case. You are representing the organization as an intervener in court. Before we get into what we're going to be arguing, can you explain what exactly the role of an intervener is?
Yeah. So, Christine, we're doing what's called a friend of the court intervention. So we are intervening as a friend of the court, which means we're not there to make arguments for either side. So although we ultimately disagree with the position that the applicants are taking, our job is not to make the Attorney General's arguments for them. We are going in to make submissions on a specific legal issue and on how we think the law, broadly speaking, should be determined. So our goal is to assist the court as they look at this matter and to help them arrive at what we believe to be a legally correct outcome.
And one of the things that our Factum, which you worked really hard on, it's really interesting stuff, is arguing is that the system of first past the post, part of that is established in the Constitution Act 1867, which makes reference to a constituency-based representation for the House of Commons, where each electoral district is represented by an individual member of Parliament. So first explain that argument, and then how are these groups challenging the system, reconciling the existence of these provisions in the Constitution Act 1867 with their claim that the system violates the Constitution? How can it be both? How can it be in the Constitution but unconstitutional?
So as I mentioned, Christine, we are making primarily legal arguments here. And so the legal principle that we are advocating is that one part of the Constitution, specifically the Charter, cannot abrogate another part of the Constitution. And this is something that the Supreme Court has said in several cases over many decades. And specifically, when it comes to first past the post, what our argument is that the 1867 Constitution Act clearly envisions a first past the post system, at least to the standard that a first past the post system is permissible under our system of government. And we see this in various provisions that establish, for example, constituencies that return a single member to the House of Commons. What's interesting is that in 1867, you can go and look at the 1867 Constitution Act, there was in fact one district, Halifax, that was entitled to return 2 members to the House of Commons. But Halifax was the exception to the rule. And the fact that the constitutional framers chose to highlight this reinforces the fact that they saw the status quo as being the first past the post system, which is what Canada inherited from the United Kingdom, because our parliament is similar in principle to the Westminster Parliament of the United Kingdom. So on that basis alone, what we are saying is that these very specific provisions which set up an electoral system, which again clearly envision first past the post, cannot be violated, or rather they cannot violate Section 3 or Section 15 of the Charter, because Section 3 and Section 15 of the Charter are general provisions and guarantees that are not designed to abrogate other parts of the Constitution.
Yeah, and they need to be read harmoniously.
Precisely.
I detected maybe a little bit of a dig in your first comment there, which is that we are making legal arguments in this case as opposed to policy arguments, which arguably some of the applicants in this case are making. And of course, it's very important to make a legal as opposed to policy argument. It's not enough to go to court and say, I don't like this system. Now, one of the other things I wanted to turn to was that this system, first past the post, was already in place when the Charter was enacted. And it has been unchanged since Confederation. So how could it just suddenly, snap of the fingers, become unconstitutional?
Well, this is precisely our argument, Christine, is that the Charter is not a revolution to Canada's legal argument. And again, you can go back to Supreme Court rulings that say this. The Charter marked an evolutionary rather than revolutionary stage of our constitutional evolution. And it's really significant, Christine, that when our Constitution was patriated in 1982, that the framers chose to preserve what came before it. They didn't repeal the 1867 Act and create a whole new constitution out of new cloth. They preserved the vast majority of what came before, with specific exceptions, which they chose to highlight. and then they added to that with the 1982 Act and with the Charter. So the fact that there is nothing in the 1982 Act which gets rid of first past the post, or which even indicates that first past the post is unconstitutional, really runs up against these arguments that somehow now first past the post violates the Charter and must be struck down.
There would have to be something very explicit to displace those provisions.
Absolutely. That's the nature of our Constitution.
Now we've got to go to commercial break, but we will continue this when we come back. When we come back, we're going to get into the arguments that the applicant makes about this notion of the Charter as a living tree and why this metaphor about Canada's constitutional interpretation is so frequently misunderstood. We will be right back.